Welcome to this explainer. Today, we're going to build a complete, top-scoring essay plan evaluating the meaning of fault and its pretty complex relationship with vicarious liability. If you're gearing up for that tricky 15-mark 8-level law question asking you to examine whether tort law is based on fault, you are in exactly the right place. We're going to unpack the source material, structure our arguments, and give you a crystal-clear roadmap for your essay.
Here's our roadmap for today. First, fault, negligence, and justice. Second, policy beyond fault. Third, the vicarious liability challenge. And finally, limits and the final judgment.
All right, let's jump straight into Section 1, Fault, Negligence, and Justice.
Let's kick things off with the absolute basics. What does fault actually mean in a legal context? I know, it sounds super simple, but in tort law, it carries a massive amount of weight. At its core, fault is all about legal blame or responsibility for a wrongdoing. Think of it like a sliding scale. At the very top, you've got intention, doing something on purpose. Slide down a bit, and there's recklessness. Down a bit more, and you hit negligence, which is basically failing to act like a reasonable person. Now, on the flip side, we have strict liability. That's where you can be held legally responsible without an ounce of personal blame. As you'll see, tort law is basically a constant tug of war between these two ideas.
Okay, so why does establishing this fault actually matter in a practical, real-world sense? Why do courts spend hours and hours arguing over whether someone was a bit careless or totally reckless?
Well, simply put, fault is the fundamental justification that explains why the state can force a defendant to empty their wallet and pay damages to a claimant. It answers the million-dollar question, should this specific person actually have to pay up? Because think about it, forcing someone to hand over their hard-earned cash without proving they did anything wrong, that would just feel incredibly unfair, right? Fault gives the law its moral anchor.
Now, to really elevate your essay and grab those top marks, we need to ask how ancient philosophy backs up this modern legal principle. Enter Aristotle. His concept of corrective justice maps onto our legal system almost perfectly. He argued that wrongdoers have a strict moral duty to repair the harm they cause. But, and this is key, it's heavily based on their level of responsibility. He split actions into voluntary and involuntary. Basically, if you cause harm through voluntary action with knowledge, intention, recklessness, or even just carelessness, you're blameworthy. Justice literally demands that you fix it.
And you know, this perfectly illustrates how Aristotle's ideas apply to the clearest, most common fault-based tort we have, negligence. Negligence is deeply rooted in fault because a defendant doesn't just automatically get sued every time an accident happens. They're only liable if they fail a very specific, objective legal test. First, they actually have to owe a duty of care. Second, and this is where the fault really lives, they have to breach that duty by failing to take reasonable care. Finally, that breach has to cause foreseeable damage. So the whole concept of negligence is built entirely around unreasonable conduct. You pay because you failed to act reasonably. Makes sense, right?
Moving right along. Section 2, Policy Beyond Fault.
This brings us to a really fascinating question. Why would the legal system ever make someone pay damages if they did absolutely nothing personally wrong? To crack this, we turn to the philosopher Jeremy Bentham.
The crucial point with Bentham is that he's all about the outcomes, the greatest happiness for the greatest number. He argues we should actually abandon the strict requirement of personal fault if holding someone liable creates greater social utility. Think about it. If holding a company strictly liable means victims get guaranteed compensation, dangerous risks are controlled, businesses buy better insurance, and unsafe behavior is deterred, well then overall social welfare improves. For Bentham, these good, practical outcomes matter way more than individual moral blame.
But hold on, what is the actual trigger that lets the law step in and apply Bentham's broad ideas of social utility? How does the state justify meddling in our private lives in the first place?
While Bentham is looking at the overall benefit to society, John Stuart Mill's harm principle provides a slightly different justification. Mill argues the law is perfectly justified in intervening the exact moment one person's conduct harms another. This is brilliant because it explains both sides of the coin: fault-based law, where someone carelessly hurts someone else, and strict liability, where the law decides that protecting people from dangerous risks is more important than proving personal blame. The trigger, according to Mill, is the harm itself.
All right, let's dive into Section 3, the Vicarious Liability Challenge.
Vicarious liability is literally the ultimate example of liability without personal fault. An employer might have done absolutely everything right, yet they still have to foot the bill for their employee's mistake. Let's look through a Marxist lens to examine the power dynamics behind why this happens. Marx helps us evaluate this purely through economics. Employers benefit from the labor of their workers, they make the profit, and their business activities inherently create risks for the public. So the logic goes, because they reap all the economic rewards, it's only fair they bear the economic risks. It shifts the focus entirely away from who morally messed up and onto the wider economic relationship.
So how does this economic reality directly challenge that original Aristotle-inspired concept of legal fault we discussed at the start of this explainer?
Well, two famous cases perfectly illustrate this total abandonment of personal blame. Take Rose v. Plenty. The employer had specifically banned employees from giving lifts on milk floats, but when a child got injured, the employer was still held fully liable, simply because the wrongful act furthered the employer's business. Wild, right? Then there's Mohamud v. Morrison, where an unprovoked attack by a petrol station attendant resulted in the employer paying damages just because there was a close connection to the employment. In both scenarios, the employers had absolutely zero personal moral fault, yet they still paid the price.
And finally, Section 4, Limits and the Final Judgment.
Here's the thing you absolutely must address in your essay. What stops vicarious liability from just totally destroying the entire concept of fault-based law? If employers are strictly liable, where does it end?
The answer is that it's heavily restrained by strict legal tests. Liability isn't just automatic the second an accident happens at work. The courts require a clear employment relationship. Plus, there must be a genuine, close connection between the job and the tort, a boundary strongly reaffirmed in the W.M. Morrison 2020 case. And let's not forget the Barclays Bank ruling, which confirmed that independent contractors are generally excluded from this rule. So the law acts as a buffer, using these policy-driven mechanisms to stop liability from spiraling completely out of control.
Which brings us to the perfect final judgment to lock down your conclusion. You can quote this verbatim. Vicarious liability is based on fault only to a limited extent. It moves beyond personal blame for policy reasons, such as compensation, risk creation, insurance, and deterrence, but remains limited by legal tests which prevent unlimited liability. As you wrap up your essay prep, ask yourself this: is tort law ultimately about punishing the wicked wrongdoer, or is it just a highly practical mechanism for ensuring the injured are made whole? Good luck with your writing. You're going to crush it.